Welcome. This is Steve Wilkes on behalf of the Wagner Law Group. I'm speaking to you from our San Francisco office, and I'm glad you're able to join us today. We are going to be talking about cybersecurity and privacy. I know there's been a tremendous amount of activity in the communication world on this topic over the last year or two. Everyone's talking about it, and there's a reason. It's really emerged as and trended as a very, very important issue given the world that we live in. So today I thought we'd have a little perspective, a little background on some of the agencies and some of the things that are happening. Keep in mind that I'm thinking primarily about financial institution, broker-dealer, and investment advisor clients, if you will, when I speak about this, though privacy has a very broad brush and data security really applies to everyone. And then we'll talk about some of the specific components that hopefully would go into a good written policy. There are a lot of agencies involved in the data security world. The SEC, FINRA, Department of Labor is emerging. It's been a little bit quiet compared to some of its other colleagues at the federal agency level, but it's showing a much stronger interest now as it relates to the employee plan world. And clearly on the welfare side and the HIPAA side, it's been prevalent for a while. Federal Trade Commission, the banks under the OCC, the Treasury Department. And there's a lot of guidance out there, a lot of rules, a lot of regulations. Every state also has its own set of statutes and regulations. I believe California and Massachusetts are often referred to as maybe leading the way in terms of being forward-thinking and progressive in terms of tackling these issues, though there are many state regulatory regimes that provide some good insight and examples into this. I think one of the big questions is, gee, is this ever going to all going to come together and harmonize and unify? Because it takes a lot of coordination to map out the issues and the applicable regulatory regime right now, and what a covered institution in terms of satisfying all these rules would have to do. So I think that's something that'll be, that'll come up at some point. And obviously this issue is of importance for many reasons. Clearly, just the cost to the economy of computer crime is really huge. We've all read in the paper about the big breaches, at Target and Home Depot and Anthem, JP Morgan. Depending on which study you look at and which newspaper article you're reading, the cost to a company, per data breach or, per compromised record can really be significant. Never mind the fact that people's privacy is being invaded, which is really important. And that kind of spills over into business continuity and some other issues. So the expense of maintaining, complying, and then not satisfying those goals is a real hard dollar cost to the economy. There's a lot of risk involved. So here we go. I thought I'd start out just a little bit. I don't want to go back and read and talk about the specifics of each of the laws. I think that would really be hard to do in 30 minutes. So it's changing so much. In fact, some of you may have noted yesterday, the day before, there was a new data breach bill introduced in the House at a federal level that got some attention. And there's just so much going on. So what I'm hoping to do is give just a little quick overlay on some of those things. We then use some some specific examples of things that the SEC or FINRA have pointed out, or that some things that have come out of other published guidelines that maybe will resonate. So if you hear something that resonates for your business and your platform, you'll be able to be asking yourself the penultimate question, which is, do I have a policy to address that? Am I on top of that issue? What we do, by the way, many of you know us in the financial service ERISA space, where we are involved with the delivery of investment management products and services. And because we are under the dual regime, many of our clients, it's not only ERISA, but it's FINRA, the Advisors Act, banking laws. By definition, we've had to get in pretty deep on the privacy issues and related data security issues over the years. And what we might oftentimes do is work with a client to maintain the benefit of attorney-client privilege, and then contract or bring in as our own consultant, so to speak, to keep the privilege line open, a technology consulting firm. Because I do not want anyone who's listening to this webinar to think that I'm a technology person. I probably know just enough to be dangerous and make a fool out of myself. So I'm going to try to stick to kind of the legal concepts and guidance and recognize and applaud our colleagues from the technology side who really understand the software and hardware implementation regime that's required here. Okay, so what is the landscape, so to speak? I mean, we have Reg SP, which everyone has known about for a while. That's referred to as the safeguard rule. It's been around for a while, and it requires broker-dealers, advisors, mutual fund companies to establish written policies and procedures that are designed to ensure the security and confidentiality of customer records and information, and protect against threats, and protect against unauthorized access. So that's been there for a while. Now, there have been some amendments, some suggestions from the SEC that would really go a lot further and deal with things like that would require a good policy to reasonably foresee, internal and external risks to personal information and personal information systems. Put that in quote, personal information being names, social security numbers, bank accounts, things that are linked together that would out an identity. Implement controls against those risks, test the effectiveness of those safeguards, and so on. So that's a really interesting, I think, piece of guidance to look at, even though it came through in the form of a proposal. It sort of gives you a bird's eye view as a checklist as to some of the things that the SEC would be looking for in terms of a good policy and compliance. We have FINRA. They clearly are reviewing and looking hard at broker-dealers, their cybersecurity programs and procedures in terms of complying with supervision and whether or not they're establishing and maintaining good supervisory systems, which, among other things, will ensure compliance with Reg SP. And there's been several rounds of published guidance, by the way, from both the SEC and FINRA. At the end of this PowerPoint, if you go back near the back pages, I put together a compendium, if you will, with links of some of the more helpful pronouncements and pieces of guidance that have come out from FINRA and the SEC over the last couple of years, to have them all in one place. And I might add, by the way, that even though we talk about cybersecurity, that usually conjures up notions of privacy and data breach. In a way, I intend to use it in a slightly larger sense, because when we think about the business, the financial service business, for example, information can cross the portal in so many ways. It can involve social media. It can involve the basic privacy rules, breach notification rules. So cybersecurity can be and should be, I think, broadly construed as a buzzword for all the different things that are happening electronically that are coming in or out of your organization, where personal information is coming over the board, and maybe that definition will be expanded. Maybe there are other items that are worthy of consideration for protection as well. In addition to FINRA, we have kind of as a category of its own, we have all the identity theft rules that have come out, and there's a host of things, the Fair Credit Reporting Act, and the OCC and the Federal Reserve System, the FDIC, Dodd-Frank. There's a lot of things out there on personal, red flags about personal identity, and the SEC kind of added that with regulation SID, which would include broker-dealers and investment advisors. So these are what we refer to as the identity theft rules. I assume that you all have heard about those. And this, basically what the SEC is saying here is that financial institutions need policies and procedures that will identify these flags, detect them, respond appropriately if detected, and then, remediate, repair the program so it doesn't happen again. Finally, we have the state laws, as I mentioned earlier, on just a host of state laws on data breach, data security, social security numbers, privacy. They all come together, and they're really pretty extensive. California and Mass, as I said, are always good examples to look at. I'm not sure I put the link up for this, but I have a pretty good chart that we try to keep current of all the different state laws that are out there. So if anyone's interested in that, they can give me a call at some point after this webinar over the next week, and we can talk about it. I'll see if I can send it to you. Okay, so what's happening out there? We know that the SEC and FINRA have been very active lately in terms of identifying priorities for the coming year. They always talk about cybersecurity, data protection, privacy. We know that they're conducting sweep exams, and you know, I mean, the SEC put out a put out a year or two ago a sample cybersecurity document that I think was meant to really help people identify their level of preparedness. And when you go through that document, it really gives you a lot of items that should be considered as part of your written cybersecurity policy. So here are some things. Just think about these things and see if they resonate for you. There's things in the general world of how you're governing cybersecurity governance, written policies and procedures. Are you making periodic risk assessments? Do you have cybersecurity insurance? How do you identify and allocate and communicate these responsibilities internally? How do you train people? What are you doing to protect your networks in terms of user access and system maintenance, things like that? For those with customer online accounts and email fund transfers that come in and out, how are you handling those? What are you doing to detect a valid trade request from a bogus trade request? How do you store that information? If you're using third parties or vendors, outsourcing in any way, how is that handled? How is that legal liability apportioned? How is the actual program developed so that all the controls are in place? How do you detect inappropriate activity? These are the kind of things that the SEC has put out as examples of your self-examination for readiness, and those are the very things that all need to be considered for your written policies as you're putting them together, reviewing them. There actually has been a lot of enforcement activity in this world. Let me give you some examples. The SEC and FINRA they brought cases for cybersecurity activity. Some of this has been in that general world of governance that I mentioned earlier. They've identified in the cases where there have not been sufficiently prepared, written policies and procedures. They've sanctioned firms that didn't comply, and the reason that these policies didn't comply, for example, they only provided limited and insufficient guidance rather than a really robust set of policies and procedures. They contained recommendations rather than mandates. They were, vague, too short, boilerplate cookie cutter stuff off the shelf. They were just generic, didn't relate to that business. They simply recited the regulation or the rule without having a policy as to how to make it happen. Didn't really understand or address the level of technology in the marketplace. Didn't give the proper instructions to your investment advisor reps or registered reps in the field. It didn't require, antivirus software. And if it did, it didn't suggest that it come from an approved whitelist, which we'll talk about a little later. So there's a lot there, interesting in the governance area. Sometimes they found adequate policies that just flat out weren't enforced. I mean, a firm had good policies in place, but there was an enforcement action brought against the CCO or a former CCO because they just didn't do what they said they were going to do. That's the blessing and burden of having good policies. The blessing is you've got a good policy in place and you ought to be congratulated. The burden or the risk is, well, once you have it, you better follow it. Nothing worse than having a policy on board and not following it. They really note there have been actions for failure to conduct periodic assessments of cybersecurity. And, for example, the SEC found in one case that a broker-dealer didn't assess the security of its trading system properly, even though they had conducted some vulnerability testing on some other systems. They weren't really focused on their trading system. They had a huge data breach. Sometimes there's a good policy in place, but nonetheless, people are smart out there, hackers and people, computer criminals know how to get in, just not responding properly to a deficiency when something is detected. They don't take timely action. You respond, but not in a timely fashion. And I think the SEC is really troubled by a firm's failure to act. it's just something that seems to really stick in them. Even instances where, like, auditors have pointed something out and the firm just doesn't take action. They're also very focused on just the regulatory enforcement has been brought in the area of encryption for failing to encrypt, non-public, customer information. For not requiring that your registered reps and investment advisors are using antivirus software. For not configuring firewalls properly. That's a word that I sounded like I know what I'm talking about. There's the technology side of Steve that's that still needs to learn some more. But that's where we work with our technology consultants on some of those things. But user access restrictions, big area that they've been very active in sanctioning firms. And just not having good passwords, or strong enough passwords. Not having a password to access a database. Is viewed, per se as a problem, or generic names like administrator or password when they ask you for your username or your password, things like that. Or not protecting your portfolio management system by allowing employees to share login credentials. More than one person getting on with the same ID, or not tracking who's been in and out of the system. Failing to turn off or disable passwords after people have left. Those are things that the SEC that they've been focused on. Issues with vendors and outsourcing, huge. FINRA brought a case against a firm that had shared confidential information with a third party vendor that didn't release the information after the service agreement was terminated. They weren't bound under the terms of the agreement to destroy or release certain data access they had. So they're looking very hard at third-party relationships and outsourcing. I think that all means going forward in the future, there's going to be a lot of activity continuing, and we read about it in the paper. We read about it in the paper every day. Let me see if I can give you some more examples. I think also remember, in terms of these items, these examples I'm giving you, the things that you're thinking about, and whether or not they resonate in your written policy. Do you have a section or policy or provision that deals with these issues? I think the kind of an overarching framework for thinking about these things is, well, in addition to just naked compliance with a specific regulation, what does this policy prevent a problem? If the problem occurs, does it detect the problem? And if the problem is detected, are you responding? Which means not only putting out the immediate fire, but then remediating so it doesn't happen again. Prevent, detect, and respond, 3 big words in the cybersecurity consulting world that have kind of, morphed over into my vocabulary as well from the legal perspective, because I think they're really important. On the password, user, and names is huge. SIFMA had put out a report back in a couple of years ago that the top 5 methods of, they found out that the top 5 methods of hacking into advisors and broker-dealer accounts and bank accounts was through either weak or stolen passwords. So that's, this notion of really strict and robust password security requirements is out there. And, would you have a policy that involves anything dealing with the complexity of a password, a minimum length? Do they expire and have to be reset? Even that can be a pain in the neck for us employees and people in the system sometime. But what are you doing? Is it unique? Is there a multi-factor authentication kind of process to it? This is something where SEC and FINRA have been enforcing and looking hard. They've imposed some penalties for failing to take corrective measures in response to an internal audit that found password protections were really weak in a proprietary trading system because they just didn't meet, industry standards, best practices. There have been fines for allowing access to a firm database because of using a generic username. I think everyone could log on under the username administrator, and that meant the whole firm could get in, crazy stuff like that. So the passwords, user access is really important. Authorized access. How do you control administrative and privileged access? Who has authorized access? Just like the whole thing with passwords, I think this is, here we're talking about, do your policies and procedures address the question as who can get in? Does it kind of, map out, is there any scheme or mapping out of user access in terms of job functions? Are there controls that prevent unauthorized people from getting in? Are there controls that detect unauthorized activity? A lot of people rely on software to maintain the integrity of their system, and the concept, I think CIFMA came out with the word whitelisting a couple of years ago. By the way, as an aside, so CIFMA has an excellent article out. It was kind of published for use, not an article, but a published guidance that was meant for use by smaller firms. It really applies across the board on things you can do to be kind of self-checking your compliance systems. And I assume that many of you have seen it. If you haven't, let me know, and I'll make sure that you get a copy. But the whole whitelisting thing is really, the bottom line is that it's the opposite of a blacklist. A whitelist is the approved list. It's the list that, utilizing an application whitelist, helps ensure that only really good software, trusted software, if you will, is put on your firm's operating system. So what you're doing is you're creating a list of approved, an approved list, and allowing only those approved applications to be on your firm. And that really helps. So it kind of takes antivirus kind of approach from a different place into a what they call default deny for files. So the whole goal of whitelisting is to stop people from downloading bad files and infecting the firm. That's what it's really all about. And filters are really important. Antivirus filters, email filters, website filters. You have to really maintain updated software, web security software, train people to be aware of this stuff. Does your cybersecurity policy call for this? Does it call for internal training? There have been sanctions. There have been penalties and fines where for example, FINRA fined a firm for not implementing procedures regarding quarterly reviews on the computers when the reviews would have detected the firm's failure to install software on at least 20 or 25 of the laptops that were floating in that system. There's the whole notion of making sure that everyone gets on a secure operating system. The idea that people utilize automatic software updates and make sure and patches, and that they're done properly and automatically without having to take any manual action. Does your policy address backing up data? Does your policy have a special section relating to mobile device security and encryption data? How those phones and handheld smart devices or in laptops are used by your people in the field. So as you can see, we just throwing out a lot of some different topics here. We've talked about some network physical security, vendor access. Again, I would emphasize being really important. Incident management. How do you respond to an incident? Do you have a state law requirement to notify anyone? Do you have a written plan in place? Does your policies call for notification? What are you doing for training? And one of the big issues nowadays is cyber insurance. That could be a whole separate webinar in and of itself. But have you thought about, just from a risk management point of view at your company, how that risk is allocated and covered financially? And there is cyber insurance available. So I think that what that means is, what's the takeaway from all of this? I think it means that you want to be, when you step back and look at this in terms of your policy, you want to be looking at, you want to review your existing policies to the extent you have them. If you don't have one, you want to put them in place. And you want to make sure that they're adequate and that they measure up to the learnings, if you will, from the SEC and from FINRA with their published guidance. And how do they just approach generally, information technology risk? Is the policy something which is understood and accepted throughout the entire firm, top down, bottom up? The whole culture of compliance that we talk about. Is there a business continuity plan in case of what happens if something does happen and your system goes down for a minute, an hour, a day? Is there some sort of business continuity plan? How do you Have you tested that plan? How, does it work? Is this all built into your policy? Is this all mapped out? Just what's the organizational structure? Who in your organization really is responsible for technology and data security and privacy and all those things? What kind of training do you have? What kind of insurance do you have? Are you specifically looking at red flags? Are you specifically looking at red flags which have been identified? So that would, the red flags might be just a failure to implement a good policy that deals with, the data protection as well as physical security. A red flag could be just not having an incident response plan in place, should a security breach occur. A red flag could be not training employees or conducting really good due diligence on your vendors and service providers and having good agreements with them, good representations and warranties as to where you stand. A red flag would be not having personnel in your organization that are responsible for any of this stuff, or for really chopping up your internal budget so there's not a lot of resources available for data security and privacy issues. Those are the kind of things that you really want to be looking at. Obviously, identity theft, the pieces that relate to individual information, name, driver's license number, account number, addresses, social security numbers, the way those things can be paired together. That's a whole area of itself that really, given all the information that's coming in overboard, when people open up an account, you're getting all kinds of information and phone numbers, alternative phone numbers, maybe assets held away, other account numbers, socials, family members' socials, locations of other accounts. There's a lot of stuff that comes in, so I think lumping this, some of it might be a little bit beyond the definition of non-public personal information as currently defined, but I think the trend is for that definition to expand. So I think it's really incumbent upon financial service firms to really look at that almost on a standalone basis and really make sure that the whole notion of identity theft is adequately covered. And I mentioned cyber insurance before. So coming up on my 30 minutes, it's so hard to do this in a 30-minute time frame, but we've been told over and over again that people really appreciate having a definite start and stop time. So let me wrap up by saying that I hope by going through this, we talked about some things that resonated kind of on a concept basis that you can either ask yourself, do we have a policy on this? Or if we do have a policy on it, is it really detailed and well thought out, or is it just kind of a token reference without a lot of thought to it? I think this is the common denominator of all the FINRA and SEC guidance that's come out, and also the same kind of guidance from the OCC, the FTC, and other agencies, is that when all is said and done, it's a world that everyone is learning. It's a world that people are continually challenged on. The bar is getting higher. It's tougher. But the one thing that the regulators like to see, and I think just as a matter of industry best practice, is to have a good internal written policy that has the right scope for your business and addresses the vulnerable areas that might be present on your platform in a meaningful and healthy manner that's really well thought out and well spelled out. And again, these policies, here's another little team of buzzwords I'll leave you with: identify, preserve, assess, search, remediate. You want to identify the problem, you want to go through some various steps, and ultimately you want to correct the problem. That's where you're trying to go. So here's a couple of pages now. If you flip through the slides, I posted up some of the published guidance, put it all in one place rather than having it spread out everywhere. You'll see on FINRA and SEC stuff, on social media, cybersecurity, and privacy. Now, our firm does an investment management webinar about once per month. I do them once a month, I should say. My next webinar, we're going to skip May, but my next webinar will be on June 11th, and we'll look forward to presenting a good topic for you and hoping to see you then. Please email me or call me if you have any questions or concerns or just want to get my thoughts on on anything involving how this cybersecurity might impact your business, and I'd be glad to talk to you. Thank you so much for attending. Hope you have a great day. Thank you.